I'll start, if the court is ready.
Yes.
I'll start with a quick correction, as is so often the case after lunch. In my keenness to get to lunch, almost the last thing I said, I skipped a line in my script. And I think I said something like, in 98.5 to 99.3% of cases, no boundary fares were bought, which is correct. I may then have suggested that that is also the figure that is identical to the class. As we have pointed out in our skeleton argument, the correct figure, once you've then applied the denominator for the people who actually held a travel card, is that somewhere over 90%, more than 90% of cases, no boundary fare was bought for in.
That's right. That's the line which is missing from the tables in paragraph 20.
Yes.
What percentage of the total journeys are carried out by people with cards?
That's right, and
that's what takes the figure slightly down.
That takes the figure slightly down, and the correct, or the answer is in Holt 1, table 6.24, which is below paragraph 6.2.72, Holt 1.
Sorry, Holt 1, tab 6, page.
No, Holt 1, sorry, that was the paragraph number in Holt 1.
Tab 6, I'm just writing the reference down.
Yes. The page number is 672. Yeah, it's supplementary bundle 2.
Yeah.
Page 431.
Yeah. Yes. Well, that makes sense. I mean, I picked up that sort of a line missing from the tables in paragraph 20 of the judgment in order to find out that figure that you've just given us.
Exactly. And
but we'll cross-refer to that and check.
The line is at that reference. You still have to do the sums, but
yes, indeed.
I make it more than 90%.
Right. Okay.
So, Mr. Harris's submissions yesterday, my learned friend suggested that this is an outlier of a case, and that's where he started, a sub category. What were those three subs? It's a top-down case, it's an opt-out case, and 3 was it has a particular fact pattern where I would say it's where individual customers might have acted differently from each other. In my submission, that describes pretty much every type of consumer-type class action that is likely to be brought under section 47C2. So I do insist that my point still stands, that I made right at the end, which is that they're trying to make the new regime unworkable. Unworkable for perhaps the principal purpose for which it was created, namely vindicating consumers' rights against dominant corporation behaviour of this kind. My learned friend, Mr. Harris, also had an equation, or a triple equation, where he equated over-inclusivity with overcompensation, and therefore uncertifiability. Now, if that were indeed an equation, then my learned friend would get home. In fact, it is not the same, as my Lady Justice Whipple pointed out in argument. Over-inclusivity does not equal overcompensation. We say that a potentially over-inclusive class may be certified in an aggregate damages case, and a number of things can happen. It can be refined, or the damages can, if necessary, be reduced by conservative assumptions, if necessary, at trial. And actually, when it came down to it, I sensed that in the end there was relatively little between my learned friend and us. I have a quotation I've written down, Mr. Harris, quote, if you have a fair and just way of removing the non-liability situation in the aggregate, unquote. And then I paraphrase, then you can go ahead and certify. Well, I say, of course, that we do. We do have a just and fair way of removing the non-liability situation, which is quite a nice way of putting it. And the cat agreed with us on the facts.
Well, his point is it needs to be done at the certification stage. Your case is it can be done at trial.
That's right, and that's partly bound up with his point that it has to be done at the individual level. That
I mean, there's no dispute between the parties, but the liability and causation have to be grappled with. Your case is it can be done in aggregate, collectively, at trial.
yes, yes,
And that will then lead to the due result.
yes. And what I say is revealing about the way my learned friend puts his case is that by saying it has to be done at the certification stage, and it has to happen at the individual level, he creates a situation where it simply cannot be done. And that's the difference in this specific part of his arguments. There is the broader point with which I agree with my lord that yes, the difference between us is we say it's for trial, and this bleeds into, as it were, the submissions made by Mr. Zhao. If we look at how the regime has developed so far, the CAT tried a mini trial in Merrick's. That went to this court and then to the Supreme Court, and the CAT was told, no, you can't have a mini trial. And so we have Gutmann, and the CAT says, right, we're going to make some sensible assumptions, and we're going to leave these complicated matters for trial. It's a low bar. Now my learned friends want this court to say to the CAT, oh no, you effectively have to have a mini trial of the evidence in order to certify. So that would be a retrograde step. That's precisely what the CAT was told not to do by the Supreme Court. So I'm going to spend, as I say, probably the rest of today on the approach to common issues in collective actions, in particular the use of aggregate damages to assess liability and causation in that sense, in the aggregate, without testing individual claimants' claims to the extent that that is being maintained. And I'll probably come on to some extent onto the methodology of Mr. Holt, and then very briefly at the end, if I have time, my learned friend's strikeout points, his 2 points that he gave 4 minutes to each of them yesterday.
Yeah, if it helps, Mr. Moser, court's content to sit till 4:30.
Oh, that's helpful. Although I still intend to deal with those points much more briefly. Yeah. Now, the original line of attack against us was, in its basic form, that there has to be an opportunity to challenge each claimant's case individually to discover how much loss they suffered, and also whether some, and if so, which ones, have suffered no loss. Now, that's self-evidently impractical. A class of 3 million members, if Mr. Harris cross-examined each one for just 5 minutes, take 250,000 hours of court time, approaching 200 years of hearings, taking into account sitting times and vacations, even if the court sat till 4:30. So this is in reality an attempt to strangle the emergent new regime at birth as regards consumer type claims, would render
5
it...
minutes enough.
Well, Lord, no, obviously it's not enough.
Several millennia, I imagine, we'd be spending.
Well, indeed. It's just so really. My learned friend very quickly segued in his oral submissions on his feet to saying, well, it could all be done perhaps by way of test cases or ADR, although that was his alternative submission. I say he's immediately driven back onto that territory because plainly you're never going to have a trial of 3 million consumers. and I'll come back to that. But I've got three principal submissions to make on the point about aggregate and the regime. So the first submission is going to be that the Section 47C regime was designed to work in exactly the way that we see in this case. And I rely on the minority in Merrick's, on what is implicit in the Court of Appeal in Merrick's, what is made express by Professor Mulheron in her article, and obiter the Supreme Court in Lloyd and Google. And also at least two further CAT cases, which haven't been mentioned yet, and I won't be going to them specifically in my submissions, but they are in our skeleton argument. They are McLaren and O'Higgins. O'Higgins is the FX case, and they are referred to as paragraphs 43A and B of our skeleton, and they follow the same line. They are, I infer, the ones my learned friend Mr Harris lamented were other cases already going the same way in the CAT. The second point I intend to make is further, and in any event, individual damage is a matter, if at all, for the distribution stage. It's not a matter for the certification stage at all. And insofar as it concerns the distribution stage, it doesn't actually concern the defendants. And this is in response to the assertion that it's somehow an infringement of the rights of the defence. And I will show the court how I say this accords with Canadian practice as interpreted by the CAT and adapted to the different wording of the UK statute. And
I'm sorry, for distribution you have to have an award of damages made, which is then handed over to the representative of the party or the third party.
Yes.
I think Mr Harris's point is to get to an award of damages for distribution, you've got to know at least that those people in the class have suffered some loss. You don't determine liability and causation for the first time at distribution.
I don't say that liability will have to be determined at distribution. Obviously we differ on whether you have to determine it before that stage. I say you don't save in the aggregate. But what I'm saying is that it's clear that issues as to who gets how much can be dealt with at the distribution stage, and they don't have to be based on the compensatory principle. So what Lord Briggs says is the compensatory principle has been radically abrogated by Section 47C, and nothing puts it back again. So there isn't a stage at which you then have to go to individual assessment of loss. It's perhaps my second point is simply a continuation of the first, but it does carry on through, if I need it. It does carry on through to the end of the process as well. And then there are different ways of distribution. And as the CAT said, it's not at the certification stage to determine how matters are going to be distributed. That's for further down the line. And my third point is really the reverse of my learned friend's point on the facts. And I say on the facts of this case, the aggregate approach to liability is appropriate. Precisely because, first and foremost, it's a case about systemic abuse. The aggregate loss is to be calculated top-down by looking at the overcharge that the TOCs actually profited from, not by a bottom-up head count of members' loss. And we see that in the judgment at paragraphs 142 and following. And so the size of the class is not determinative of the size of the award in this case. Hence no overcompensation. Third, we say the instances of potential non-loss are on any view a small percentage proportion. Many of them wholly de minimis, like people perhaps forgetting their travel card or willingly paying more and so on, as the CAT found. and the aggregate damages may be adjusted to accommodate such cases. So on its own facts as well, we say this is a case that is eminently suitable for the approach the cat has taken. And it is worth remembering that we say the loss is calculable at least almost entirely at the defendant's end. And the defendants are in no danger of any significant overestimate of their liability, regardless of individual customer experiences. Now, the first point, which is the fundamental point that my learned friend does also still contest, is how the regime is meant to work. So section 47C, it is said against me that it cannot be overcompensatory. As I understood it, my learned friend's argument went so far as to say that if there is even one potentially uninjured class member, the claim cannot be certified. The whole edifice comes crashing down. And the point need only be articulated in this way, in my submission, to see immediately that it must be wrong. I could take the Merrick's minority point relatively briefly, not least because I suspect it's very well known. The way the CAT treated this was by looking at the Canadian and the UK case law together, pointing out the similarities and importantly pointing out the differences. And this is at paragraph 106 and following of the judgment, page 173 of the core bundle. Just worth having a quick look. 106 on 173, the last sentence, as both judgments in Merrick's also observe, there are some differences between the Canadian and UK statutory structures. Those differences also have significant implications. The following principles are set out in 107, derived from the Canadian Supreme Court case law. Interpreted purposively, not necessary for common issues to predominate over non-common issues. Common issue does not require all of the members of the class to have the same interest in the resolution. So it's the question and not the answer that must be common. No significant level of difference between the position of class members. Question may receive varied and nuanced answers. I'm sorry, there can be a significant level of difference between the position of class members. The question may receive varied and nuanced answers, depending on the situation of different members. For the standard to be applied in assessing expert evidence is that it must be sufficiently credible or plausible to establish some basis in fact for the commonality requirement, not purely theoretically, grounded in the facts of the particular case, with some evidence of the availability of the data to which the methodology is to be applied. But this is not an onerous evidential test. My learned friend Mr Jowl read out most of 4, but not the last 2 lines. And how was this treated by the Court of Appeal in Merrick's? That is in Authorities Bundle 2, at tab 14, page 526 of the bundle. This is the part that my learned friend Mr Harris has already taken the court to. And it's worth recalling, a critical issue in deciding whether the proposed methodology is a suitable and effective means of calculating loss to the class is to determine whether it is necessary to prove at trial that each member of the proposed class has in fact suffered some loss due to the alleged infringement. And again, the first line of 47, to require each individual claimant to establish loss in relation to his or her own spending, and therefore to base eligibility on a comparison of each individual claim would, as I have said, run counter to the provisions of section 47C2. My learned friend Mr Harris sought to recharacterise Merrick's by saying, oh, this was a case where everyone was bound to have suffered some loss. He says, well, I was counsel in that case. He says he's therefore able to see it through a very particular lens. I submit with respect, he was to some extent giving evidence, because that's not what it says in the three judgments in Merrick's. It is not what the cat judge in Merrick's thought, and for that purpose, I'm going to come back to the Supreme Court in Merrick's in a moment, but if we can just look at the judgment in this case, in the core bundle, at page 177 of the core bundle. So that is Mr. Justice Roth and the rest of the tribunal. And he says at paragraph 113 of the judgment below, I'm sorry, it's paragraph 112 of the judgment below. It's just above the first hole punch at the top of 177. Moreover, that bit, moreover, there may well be members of the class who suffered no or only minimal loss, this is about Merrick's, because in the sectors and locations in which they made purchases, there was no or minimal merchant pass-through, at least for certain parts of the class period. So that's the trial judge in Merrick's, and he says a similar thing at paragraph 129 of the judgment below, at page 184. It's also not what was submitted in that case. We've made this point in our skeleton argument, but in the authorities bundles, we can put away the cat for now, but in the authorities bundles, for some reason, in bundle 6, in bundle 6 at tab 55, is MasterCard's response to the CPO in Merrick's. And if we look at pages 1840, 180, 1840 and following, what is said at paragraph 27 by MasterCard is the power to make an aggregate award does not mean the tribunal may award damages which do not reflect losses actually suffered, nor may it award damages to represented parties who have in fact suffered no loss. And at 1841, end of para 30, aggregate damages are a means by which losses can be proved on a collective basis. They're not a means for claimants to recover damages where they cannot prove what loss, if any, they have suffered. And at 64, page 1853, there's a similar point made in relation to the tribunal guide. At the end, individual claims, including some individuals who may have suffered no net loss and therefore should have no entitlement to any damages. Now, it's hard to square that with the situation where it's said from the bar, there was bound to be a loss in every purchase in Merrick's. It was also suggested there were no issues in Merrick's about whether a consumer would have acted differently in the counterfactual. I'm sorry, it's worth actually hanging on to this. That there were arguments, of course, about the individual issues at merchant level that meant there must have been differences, whether and to what extent MasterCard was liable to each individual consumers, depending on which merchant they interacted with, and that individual merchant's pass-on rate. And if the court still has that MasterCard submission at 1852, there's the reference at little c, in the middle of the page, material differences within each of the sectors identified in the expert report. Other retailers cannot simply be assumed the pass-on rates of John Lewis and W.H. Smith will be similar. Similarly, in the entertainment sector, cannot be assumed pass-on rates of HMV would be similar to those of Comet, etc., etc.
Sorry, which paragraph are you reading from?
I'm reading from paragraph 61C. 61 actually starts on 1851, but I'm reading from little c on 1852. These are examples of individual issues in another case that did not preclude certification in that case, And the fact that the individual issues arose at merchant rather than consumer level, I submit, makes no difference. It may be assumed as a matter of common sense that in a class as super inclusive as Merrick's, there are bound to be vast differences in the situations of different class members.
There'll be different markets which will be subject to different competitive pressures, and they may respond differently.
And what, yes,
They may have a greater or lesser ability to perform a pass on.
indeed. But Lord, it's also a matter of common sense that there will be some in a class that includes essentially everyone of age for the relevant period who may have suffered no loss. And so we do resist this idea that even in the first certification there is no chance whatsoever that there is no class member who may have suffered no loss. And I'm sure, I don't make this mischievously or in any other way, but I'm sure that my learned friend Mr Harris would not contend that the class in Merrick's should come crashing down on that basis. And we know it hasn't. So there we are.
So in a sense, the Court of Appeal wouldn't be dealing with the point at in the first sentence of paragraph 47 if there weren't an issue about those members of the class who hadn't actually suffered a loss.
My Lord, indeed, and that, your Lordship has correctly anticipated the next line in my script, which is look back at Merrick's Court of Appeal at paragraphs 45, first sentence, and 47, first line. And you can't square what it says there with a situation where there's no chance of there being no loss. That's exactly what the Court of Appeal was addressing. Moving on then to the Supreme Court in Merrick's, which is at Authorities Bundle 2, tab 16. Much of this is familiar. I'll take it as briefly as I dare, but obviously I have to make submissions on it. There is in the majority the important paragraph 58 in the judgment of Lord Briggs, that I've already cited, as it were, freehand. Basic feature of the law and procedure for determination of civil claims for damages is, of course, the compensatory principle. As the CAT recognised, another important element of the background against which the statutory scheme for collective proceedings and aggregate awards of damages has to be understood, but in sharp contrast with the principle that justice requires the court to do what it can with the evidence when quantifying damages, which is unaffected by the new structure, the compensatory principle is expressly and radically modified. Where aggregate damages are to be awarded, Section 47C of the Act removes the ordinary requirement of a separate assessment of each claimant's loss in the plainest terms. Nothing in the provisions of the Act or the rules in relation to the distribution of a collective award among the class puts it back again. The only requirement, implied because distribution is judicially supervised, is that it should be just in the sense of being fair and reasonable. And there is then the minority view on which, however, we say there is no difference in relevant part between the majority and the minority, starting at page 629 of the bundle, on aggregate damages, 93. It's called a major innovation in terms of UK law, affected by Section 47C2. Referred to in the CAT rules as an aggregate award of damages. As pointed out by Professor Rachel Mulheron, two functions, and that is then explained under F. The first concerns the quantification of loss, and that is expanded on. And then just above G, this involves a departure from the normal compensatory principle, whereby the object of an award of damages for a civil wrong is to put the claimant as an individual in the same financial position as if the wrong had not occurred, it is clear that section 47C2 is intended to serve this purpose. And then at 95, a provision for aggregate damages may, however, go further and serve an additional purpose. It may also permit liability to be established on a class-wide basis without the need for individual members of the class to prove they have suffered loss, even though this would otherwise be an essential element of their claim. So we have the two functions. The first is to quantification, the second is to liability, and the second is addressed at paragraph 95. It goes on, of course, through to 97, discussing the Canadian situation, including process, and the finding at 97 that the UK legislation is not limited in this way. We urge upon the court to find that the minority view in Merrick's not only accords with the majority view, because they did not differ on this point, but is also, and in any event, obviously the correct reading with respect of section 47C2. And using the language of the test in Pearson, cited by my learned friend, I submit it is a necessary implication into the statutory language, and it must be able to work this way. Otherwise, the regime can't function. And there is also in the authorities, it's been referred to, but as yet I think unseen, at Authorities Bundle 6, a copy of the article by Professor Mulheron, Bundle 6, tab 49, starts at 1592. One of the relevant sections is at 1612. Starting between the hole punches at I'm going to start reading in the paragraph that starts with the Canadian Supreme Court citing Hansard. About halfway down there's a sentence, as some judges and scholars have noted, unless an aggregate assessment provision is given an interpretation via the liability approach that circumvents any need for individual class members to establish causation of loss or harm to themselves individually, then the potential of the class action for redressing widespread infringements and enhancing access to justice will not be realised. And there's a reference to it being still controversial and far from settled in Canada. Sixthly, and in this author's view, the Court of Appeal in MasterCard was entirely correct in applying the liability approach, even though it is not the approach that process affirmed. And there is that perhaps arid discussion adverted to by my learned friend Mr Harris as to whether citing process on this point in paragraph 46 of the Court of Appeal was on point or not on point. I say, of course, it doesn't really matter in the end. The findings of the Court of Appeal are plainly correct, and that's the view that Professor Mulheron comes to as well. And the passages continue. Sixthly, she points out that section 47C2 could have produced something like the British Columbian provision but didn't, and that's about the democratic intent that my learned friend addressed. Well, they didn't show the same intent as the legislator in Canada. And seventhly, and to conclude on page 1613, section 47C2 does not provide the same interpretative difficulties as has arisen in Canadian jurisprudence, does not insist on the quantum approach, doesn't require that no issue of fact, e.g. proof of damage, can be outstanding before an aggregate award is made. That's the key difference where the Canadian courts have found that's why you can't have an aggregate award. And the divergence of wording between Canadian and UK statutes was one of the many instances in which the UK lawmakers did not follow their Canadian, or indeed other jurisdictions' statutory counterparts. And there is the point made by the learned professor that section 47C2 can amend the substantive law, and it has in fact done so. It is not necessary each class member prove a personal loss in order to prove a cause of action for breach of statutory duty. And hence, whilst the Court of Appeal citation process was actually misplaced and so forth, it was entirely correct. And then that paragraph concludes that section 47C2 properly permits an aggregate damages award both to prove the loss on a class-wide basis and then to assess that loss suffered by the class. And we respectfully agree. And that, of course, was also the conclusion of the Supreme Court's, admittedly, obiter in Lloyd and Google. Lloyd and Google, I won't turn it up, but for the reference of the court, it's in Authorities Bundle 2, tab 19, and at page 727 of paragraphs 31 and 32, where Lord Leggatt makes that same point. While I'm mentioning Lloyd and Google to the court, can I just point out that in my learned friend's skeleton, he relied on Lloyd and Google and briefly touched on it orally as well, to say to the court, well, here you have a group litigation order without compensatory and individual losses being proven, and it was found not to be appropriate. But I say, obviously, that doesn't assist him. Lloyd and Google was a case brought under Rule 19.6 of the CPR, the GLO provision. And that was precisely one of the rules that was found to have been wanting in the papers that led up to the passing of the Consumer Rights Act 2015. The example that was cited was the case of Emerald and others against British Airways and others, the air cargo case. That case, it's probably worth just turning up Lloyd and Google just to make that point very briefly. It's at Authorities Bundle 2, tab 19. 3, I'm so sorry. Tab 19. If we look at page 742, there is paragraph 80 of Lord Leggatt's judgment, and he says, as already discussed, it is not a bar to a representative claim that each represented person has in law a separate cause of action, nor that the relief claim consists of or includes damages or some other monetary relief. The potential for claiming damages in a representative action is, however, limited by the nature of the remedy of damages at common law. What limits the scope for claiming damages in representative proceedings is the compensatory principle, on which damages for a civil wrong are awarded, with the object of putting the claimant as an individual in the same position as best money can do it, and so on. And therefore, representative action is not a suitable vehicle. But that is self-evidently about the 19.6 CPR regime. It is, I would say, the antithesis to the Consumer Rights Act regime under section 74C. So not only does it not assist the TOCs at all, it is the perfect illustration as to why section 47C had to be introduced and how it's meant to work. In other words, exactly not like this, but exactly the way that is explained in Merrick's, Lord Leggatt's judgment in Merrick's and in Lloyd and Google, and in the CAT in this case. And there is then, in this line of case law, the next case would be Le Paterel. I'm not going to address this court on Le Paterel, and for obvious reasons. I don't have to. I'm asking this court to make the relevant findings in this case, whatever the observations in Le Paterel to similar effect. But it's obviously paragraphs 9, 25 and 29 of your Lordship's judgment. My learned friend also referred in passing to Gibson, Gibson and Pride. I'm just going to say that also doesn't assist him at all. That was a pre-Merrick's case. Nothing there about compensatory or otherwise, because that hadn't been established. Now, we say that the way that the CAT has applied this case law is entirely in accordance.
Just before you move on,
Yes.
could I ask you just to help me with the language of section 47C?
Yes.
Because as I understand it, it's effectively a process-driven provision which says that the tribunal need not undertake what is described as an assessment of the amount of damages recoverable. Now, Mr. Harris is absolutely right, it doesn't use the word liability, but as I understand the appellant's case, what would have to happen is some form of assessment by the tribunal of the amount of damages to see whether it was A, zero and or B, nominal, and if so, it's therefore outside the class or its certification fails. But you have to carry out an assessment of the amount of damages recoverable to decide whether it's zero or nominal, which is that which, at least on one view, 47C2 says you shouldn't do. I'm trying to get my hand around the process which the appellants say the tribunal must carry out in order to decide whether there is some loss or nominal loss which should be disregarded.
The key to it, in my respectful submission, is the last few words of that provision, which is in respect of the claim of each represented person. So it is not, as is being suggested, an instance where you are simply looking at a lot of individual common law claims for compensatory damages grossed up into a collective action. You're looking at an aggregate assessment of damages of the class without having regard to the claim of each represented
I think
person.
my point's slightly different. If Mr. Harris is correct, it would require the tribunal to conduct an assessment of damages recoverable in respect of the claim of each represented person in order to decide whether it was zero and or nominal.
Absolutely. Absolutely. There's also a slightly, if I may say so, peculiar insistence in this context on there having to be some loss, however nominal. When you're talking about an aggregate damages claim, I don't need this point, but I simply say, almost in argument, what does it matter whether somebody has suffered 1 pence of loss
72 pence.
or zero? When you're looking at the class as a whole, obviously that matters. If you're doing a compensatory type claim, an individual has to show that they have suffered loss, but we're told that is not what we're doing here. So whether you've suffered 72p or 1p of loss or 0p of loss, it really doesn't matter for the purposes of section 47C2. And
So it doesn't matter if that person is included, because it will never lead to an increase in recoverable damages as an aggregate.
exactly. And that's where all the arguments about what you're going to do at trial come in. There's no infringement of procedural rights, for instance, in taking that approach. If they want to lead evidence to say, well, 2% of people forgot their travel cards every day, or 1% of discount fares would have been cheaper, they can make those points at trial with evidence. They can then be taken into account, but they're not taken into account in respect of the claim of each represented person. They're taken into account in the aggregate. And once one makes that leap, I submit, in all these difficulties that are being laid in our way, simply melt away, at least at the certification stage, because they will be for aggregate assessment at trial.
Yeah, I also noticed that you made slightly earlier this afternoon one of the points, your second of your 3 submissions about individual damage being a matter at the distribution stage, that's actually exactly what Lord Leggett says in Lloyd and Google, page 1280, towards the end of paragraph 32. No doubt in many cases a just method of distribution will be one which divides up an aggregate award of damages in a way which takes account of individual loss. But the end goes on to say it may not be practical to do that, it may just be a question of effectively dividing up the cake between the number of people who
Exactly.
are in the class.
Exactly. And no doubt in many cases it will. He's undoubtedly right. In some cases it won't. And then you give $2 per pair of jeans or whatever. And one of the points that the cat made about our case is that when we pleaded our case, and indeed when we put together our litigation plan, that was before Merrick's. So we put in place a particular suggestion as to how we thought this should be distributed. And the cat said, well, let's see, you would be entitled to make other suggestions about distribution in due course, depending on what suits the facts of this case. The implication being, it may well be that there will be a distribution of so and so much per head. And my learned friend would say, oh, well, there you are, overcompensation. But that is, I submit, precisely the wrong lens through which to view this, because in the aggregate will not be overcompensation, because they will only have been, had to pay an award of whatever it is that was the overcharge from which they benefited. On our case, abusively and illegally. So we say the whole argument about overcompensation is a massive straw man. We are not saying that we're departing in that sense from the compensatory principle even. It's just adapted to meet the conditions of a collective action with an aggregate damages provision, such as section 47C, to apply to the aggregate loss of the class rather than any one single individual. And we will put forward our evidence, and that includes the survey that I'll come back to. We will see what their disclosure brings, whether it will indeed be as barren as Mr. Harris suggests or not. They put forward their own evidence as to what they say. They'll say, oh, well, perhaps they'll say no one has suffered loss, or whatever. If they're right in that, they'll win. And there'll be a trial of the evidence, and at the end of it, somebody will win. We say it's us, and there will be an aggregate award. Now, this may be an appropriate moment to deal with the overseas, at least the Canadian cases, because the CAT based itself on the Canadian cases and then adapted what was found in Canada to the situation of section 47.2. And at the certification hearing, Southeastern and Mr. Harris relied on what they called their trilogy of Canadian cases, Dennis, Muteros and Kett. Yesterday, Mr. Harris relied on at least two of the trilogy, saying that they establish a proliferation of individualized issues of causation means that claims should not be permitted to continue collectively. It's a slightly different point, I suppose, because once we are within the universe of Canadian cases, there is at least a recognition that matters may proceed in the aggregate. But he says, but too many individual cases mean you can't continue collectively. So I would like briefly to distinguish Dennis and Muteros, at least on that second point, for what it's worth.
Do you challenge in any way the conclusions of the CAT as to the Canadian cases in 106 onwards?
No. Your Lordship may be about to tell me I don't have to bother.
No, well, we didn't have a challenge to the pulling together of threads by the CAT from the appellants.
there was reliance still placed on the terrorist intent. I can take it relatively briefly.
Up to you.
I mean,
I'm not being paid. I'm not. You. Not as much as you.
Your Lordship isn't being paid by the hour. But the UK statutory regime is fundamentally different from that in Canada when correctly interpreted, because it permits liability as well to be established in the aggregate, whereas Canada doesn't go that far. So there is that difference. Well, taking it relatively briefly, one of the arguments that my learned friend advanced, when he had, I sense, retreated from his absolutist position that any instance of potential no loss brings the whole edifice crashing down. One of his suggestions was, well, you could have a two-stage trial. The first stage about the common issues that advance matters, and then you go on to a second stage and assess individual cases. Now, in its first iteration, that doesn't actually help with the 250,000 hours of case hearings, because it simply postpones the evil day to your notional stage 2. Now, at that point, my learned friend pointed out that actually he understood that wasn't what actually happened in Canada, because in fact the cases tend to go to ADR and either settle or otherwise come to an end at that stage. My learned friend said, I quote, "Not many go on to fight these trials," unquote. Well, I bet they don't, and they say so, because who would? And I have to say, that doesn't sound to us like the best part of the Canadian system, with great respect for our Canadian cousins, nor something, in my submission, that Parliament can be presumed to have intended to import wholesale. We have seen from the article that Professor Mulheron wrote that there are difficulties with the Canadian approach, and indeed some misgivings, and one can immediately see why a two-stage system where you don't really ever reach the second stage is not really just or fair. I mean, for either party, I know I'm representing the class representative here, but the court will be looking at the system as a whole for both sides. It's hardly fair for the defendant to have in terrorem this terrible two-stage trial, where at stage 2 there might be at least weeks or months of complicated test hearings. And we know also that the system in Canada is perceived by some to need something like our Gutmann UK approach. And we see that, for instance, in the article that we have brought, referred to by Professor Mulheron, the article by Professor Craig Jones, which is at Authorities 6, tab 51. It's the article entitled Panacea or Pandemic. Now, I won't delve into the details of the complications of the Canadian experience. There is a section starting at page 1719 headed Assessment of Liability, Harm and Damages on an Aggregate Basis. There's a reference to a number of cases, and in the sidelined bits at 1725, Professor Jones comments, recent Ontario decisions seem also to hint at the willingness of courts to entertain questions of liability on an aggregate basis. And he makes reference to a case called Ramduff and George Brown College. And over a couple of pages, I obviously invite the court to have a look at this to the extent it wishes in their own time. But at 1729, by the second hold punch, having made a number of points around the cases, and aggregate assessments, he says the same points can and should be made with respect to liability. If class-wide causation can be fairly and reasonably determined without individual proof, then class action judges should do so routinely and without hesitation. And we appear to be cautiously starting down that road. This is how it should be, recognising that class proceedings acts did not in themselves modify the substantive law does not mean that they froze the substantive law at the time of their enactment. And that's, of course, the debate happening in Canada. I say it's different here. And over the page, 1730, an interesting point with respect. Finally, I cannot resist pointing out that aggregate assessment of liability already underpins the judicial resolution of mass wrongs in Canada. Most certified cases settle before trial, I say, as Mr. Harris says, and the settlement terms are subject to judicial oversight and approval. These settlements routinely rely on estimates of the global liability of defendants to groups of persons without proof of individual loss. If one is substantively procedurally, institutionally or circumstantially fair, as class action settlements must be, then how can the other, the use of the same devices to determine a fair outcome of trial, not be? He asks rhetorically. And I say again that the idea that you have a system that, for whatever reason, makes people settle before trial, and I submit because it's simply unworkable at trial, is not a system that we ought to copy. Having made that general point, I did say I would try to distinguish at least the two authorities that my learned friend referred to already from the present case. I say they can be distinguished, and for the reasons given by the tribunal. I don't differ from that. Muteros, Dennis, and indeed Kett, which was the third in the skeleton argument, none involved a systemic wrong. And as the tribunal said at paragraph 114, our case is advanced on the basis of a systemic failure, focusing on the manner and extent of the availability of boundary fares, both as regards outlets and types of fare. And the lack of information, the customer experience was the same for all customers. Each class member was exposed to the same lack of availability and lack of information about boundary fares across the piece. And I will also note, perhaps mischievously, that although Southeastern has placed a lot of weight on the Canadian authorities, Southwestern don't. And perhaps implicitly consider that the Canadian authorities do not assist them that much. Now, the tribunal has given its summary on Dennis at paragraphs 83 and 84, and then its comments at paragraph 114, distinguishing Dennis from the present case. And I'll just show the court, if I may, again, paragraph 114 at page 178 of the first bundle, the core bundle. 114. The first one is Dennis, the problem gambler case.
Yeah.
The claims focus, the present claims are advanced on the basis of systemic failure, by contrast with Dennis. The claims focus on the manner and extent of the availability of boundary fares and so on. And then there's the reference to it not being far-fetched or implausible to contend that whether the systemic breach is accepted in whole or in part doesn't depend on individualised consideration of each customer. Dennis, my lady, my lords, is simply a case that on its facts is so far removed from the present case as to be of no assistance whatsoever. In Dennis, there were factors that were specific to individual class members that affected the question of whether OLG was liable at all. And there were individual issues all down the line. It's probably worth just looking very briefly at Dennis It's at Authorities Bundle 3, tab 25. Starting at 935, it was the case around, we see on the head note at 935, it was the case around the problem gambler. The very first line of the head note under held is this case was not one involving a systemic wrong. And then if one looks at paragraphs 54 and following of the judgment, my learned friend went to briefly, there's all the examples on page 948 of cases where liability essentially turned on unilateral actions of the defendant. In 55, the claim at issue here does not fit that category. The central problem is the alleged fault of OLG does not turn solely on the execution of the contract. It is inextricably bound up with the vulnerability of the individual class members. These were the problem gamblers. The complaint against OLG is that it failed to prevent them from harming themselves. Now I take this point and I say, far from showing what my learned friend says, that this is somehow all of a piece with us, liability that essentially turns on the unilateral actions of the defendant, I say, is precisely the sort of case that we are dealing with here. Liability on our case turns essentially on the unilateral action of the defendants in double charging their customers by hiding the availability of boundary fares. And if one goes on to 57, the issue of OLG's alleged fault cannot usefully or fairly be considered in the abstract and without reference to the circumstances of each individual class member. When we say it absolutely can be. And whilst there is an element to which Mr. Jowl has a point of course, you have to consider some features of the class in the aggregate. You do not have to consider, we say, the circumstances of each individual class member. That was the case in Dennis. And that was the basis on which a statistical approach to establishing aggregate liability was rejected in that case. But that in itself is not surprising. That's very readily explained by the fact that statistical proof of liability is not acceptable in Canada. We know that as explained by, for instance, the minority in Merrick's, paragraph 96 of Merrick's. The Canadian legislation has not been interpreted as allowing liability as well as the quantum of loss to be established on a class-wide basis. And there's reference to Process and Microsoft. So it doesn't assist on the facts or the law in my respectful submission. And a similar point applies to Muteros. That is in the same bundle at tab 23. That was the case of the the for-profit post-secondary educational institution called DeVry Canada. And they tried to have a class action on behalf of the students who had allegedly suffered misrepresentation. Now, the conclusion of the CAT, in our case, on Muteros, is having cited the facts of the case at 85 and 86 of the judgment below, they conclude at paragraph 115, I'll just read it out. The distinction, they mean from the present case, is even starker with Muteros, claimed for all college graduates. And I'll skip a bit. Muteros was a misrepresentation case where many of the class members may not have seen or heard the alleged misrepresentations or relied on them, which are fundamental elements of a misrepresentation claim, and many class members appear to have suffered no loss. And my learned friend says, well, how doesn't that, why doesn't the CAT see that that can be levelled equally at the present claim? And that's, again, very simply answered. A misrepresentation claim is fundamentally different to a competition law claim under section 47B as a collective action under section 47C of the Competition Act, under which liability and damages can be proved by aggregate evidence, we say. And in contrast, misrepresentation, of course, requires proof of individual reliance, which you can't do in Canada. And unlike in Muteros, every member of our class has been exposed to the same abuse in principle. In Muteros, nobody could say whether people had or hadn't been in receipt of the operative misrepresentation. Again, both on the law and the facts, Muteros does not take us further at all. And Ket, I wasn't mentioned yesterday, but it is an even more extreme example in my respectful submission of the same thing. And then my learned friend also referred to Pioneer and Godfrey in his submissions. As the tribunal explained at paragraph 103 of its judgment below, Godfrey was a claim concerning a price-fixing cartel amongst producers of optical disc drives, ODDs, and ODD products. The proposed representative plaintiff sought to bring a class action under the British Columbian CPA on behalf of direct purchasers, indirect purchasers, and umbrella purchasers of ODDs. And one aspect of the appeal concerned the required standard to certify loss as a common issue, and whether the expert's evidence, someone called Dr. Reuter, satisfied that standard. And Godfrey is at Authorities Bundle 4, tab 34. Facts are summarised at 1163 to 1164. At 1167 is a reference to process. In order for loss-related questions to be certified as common issues, the plaintiff's expert methodology need only be sufficiently credible or plausible to establish that loss reached the requisite purchaser level in that case, which was about the standard to certify loss. It is not necessary that it establish that each and every class member suffered a loss, nor must it be able to identify those class members who suffered no loss, so as to distinguish them from those who did. And there's a reference there to Process and Microsoft. In Process, the court directed for a court to certify loss-related questions as common issues in the price-fixing class proceeding. It must be satisfied the plaintiff has shown a plausible methodology to establish that loss reached one or more claimants at the purchaser level. And then there's a reference to indirect purchases. Turning on
There's an observation in 104 of the Cat's judgment, referring to paragraph 109.
Yes.
About the essential features of an issue that is common, which is it's an issue which is capable of being litigated in common. And it really is all about manageability. It's a common issue if it's capable of being grappled with, I suppose, sensibly in some way by a court at trial. Is that fair? Is that a defining feature of something which is common? It really goes to its intrinsic justiciability. Can the court deal with it properly in a single forum at a single time?
Well, I submit it is. And at 109, of course, the court was dealing precisely with what is required of an expert methodology at the certification level. And I submit that is about the right bar, which we're told is a low bar for that level, which can be read across into what the CAT did in this case, which is no doubt why it's referred to. I'd also point to paragraph 102, which is at page 1219, where the judge says, in any event, even were the expert's methodology incapable of showing loss to every class member, as I explained below, it is not necessary, in order to support certifying loss as a common question, that a plaintiff's expert methodology establish that each and every class member suffered a loss. Nor is it necessary that Dr. Reuter's methodology be able to identify those class members who suffered no loss, so as to distinguish them from those who did. Rather, in order for loss-related questions to be certified as common issues, the plaintiff expert's methodology need only be sufficiently credible or plausible to establish loss reached the requisite purchaser level. Leaves only the question being whether courts below were correct in finding his methodology satisfied that required standard of commonality. I see no reason to interfere with the certification judge's determination that it satisfied this standard. And we say, obviously with some adaptation to the facts, that is what we submit is appropriate in this case. Also, my learned friend, I believe, referred to, no, but before I go there is also, interestingly I submit, at 108, the passage that begins additionally, showing that loss reached the indirect purchaser level satisfies the criteria for certifying a common issue, since it will significantly advance the litigation, is a prerequisite to imposing liability upon Toshiba and will result in common success, as explained in Vivendi, given that success for one class member will not result in failure for another. Showing loss reached the requisite purchaser level will advance the claims of all the purchasers at that level. And it may be just worth to have marked the cross-reference to Vivendi, which is in the same bundle, I believe, at 1040, the relevant passage in Vivendi. So that's tab 7, page 1040. And at paragraph 45, what the Supreme Court there said was, having regard to the clarifications provided in Rumley, that's the first paragraph on page 1040, it should be noted that the common success requirement identified in Dutton must not be applied inflexibly. A common question can exist even if the answer given to the question might vary from one member of the class to another. Thus, for a question to be common, success for one member of the class does not necessarily have to lead to success for all the members. However, success for one member must not result in failure for another. And before Vivendi, it was thought that perhaps to be common, success for one member had to mean success for everybody.
This is the point I think the tribunal summarises at 1073.
Yes.
I mean, an issue is not an outcome.
That's right.
It's the issue to be tried, which will then lead to a determination, yay or nay, or somewhere in between.
Yes. We keep coming back in this way, my lord, to the question of what is the bar at the certification stage? How high or how low is it? And again, in Merrick's CAT, the Competition Appeals Tribunal applied a relatively high bar, was told it was wrong in Merrick's Supreme Court. They have applied, in my respectful submission, precisely this sort of bar that we see illustrated in Vivendi and in Godfrey. And now my learned friend says, oh, well, that's wrong. You need much more evidence. You need much more by way of the expert showing a detailed methodology, and it just isn't there. Now, it is right to say that, of course, we know the conclusion in Canada is somewhat different, because in Canada they say, well, eventually you have to work out the individual loss. And to that extent, that there is just a difference between us. And my learned friend has referred to paragraph 118 in Godfrey. That was the one where the judge said, I agree, the Act permits individual members of the class to obtain a remedy where it may be difficult to demonstrate the extent of individual loss. What the jurisprudence of this court maintains, however, is that in order for individual class members to participate in the award of damages, the trial judge must be satisfied that each has actually suffered a loss, where proof of loss is essential to a finding of liability, as it is for liability under Section 36 of the Act. Therefore, ultimately, to use the aggregate damages provisions, the trial judge must be satisfied, following the common issues trial, either that all class members suffered loss, or that he or she can distinguish those who have not suffered loss from those who have. But the interesting thing about that passage is it goes precisely with respect to my Lord's point. That is for the trial judge, as paragraph 118, the paragraph my learned friend relied on. It's not the certification stage. And that's really all I wanted to say about Godfrey. The last case that my learned friend relatively briefly touched on was the case of Loblaw. David and Loblaw, it's the Ontario case, it's Authorities, tab 39. I don't propose to say very much about that at all, save that that was the case about bread. It was the case of a price-fixing cartel allegation in relation to packaged bread, and it was said that the cartel had had an impact on the prices paid for other products, such as fresh bread. And the absence of any methodology was found in Loblaw to be insuperable. But there's no tenable parallel between Loblaw and the present claim. There was no methodology proposed at all in Loblaw for demonstrating that a price-fixing cartel in relation to packaged bread had an impact on fresh bread. So it's quite different, my lord, from not yet having a fully worked out methodology at the certification stage. Although in any event, of course, we say we have already worked out methods for removing any uninjured class members. So that really brings us back to where we started, my lord, with your lordship's question, do you differ from what the cat said? And I say, no, I don't differ from what the cat said. And what the cat said in its conclusions at paragraphs 114 and 115, at page 178 of the core bundle, is what I say, gratefully. I distinguished Dennis, Buteros, and indeed Kett. Kett was that case where it was completely impossible to determine whether any class member had suffered loss at all. By contrast, the last sentence of 115 in the present cases, where the claims are for systemic breaches, what we regard as the common issues, as set out below, and I started with those before lunch, appear much more significant than individual issues. And we agree. I will touch briefly, if I may, on issues of distribution, as I said I would. So that's the front end, as it were, the certification stage. There's then the trial. As we know from Merrick's, the compensatory principle is abrogated, and nothing puts it back again, including at the distribution stage, as is stressed in various places in the Supreme Court in Merrick's, both at the both in the majority and in the minority judgments. I'd like to illustrate by just reference to one of the CAT cases, McLaren, how this works, at least on the facts of that case. That's Authorities Bundle 3, tab 20. McLaren is a CPO application case, like this one. The follow-on claims in relation to an infringement decision for the maritime car carriers decision. I won't trouble the court too much with the facts, but I'll point out what the CAT said in that case. at paragraph 61 and following at page 785. In our view, it is not fatal that some of the class members have not suffered damage in a manner that would be quantified by the proposed methodology. All of them acquired vehicles during the cartel period. And the common issue, that is, the question arises of the extent of pass on to them. It is also clear from Merrick's that the power to award aggregate damages is far-reaching, removes the need separately to assess each claimant's loss, judgment of Lord Briggs, Lord Sales and Lord Leggett. The risk that the application of the proposed methodology may result in certain members of the class being found not to have suffered any quantified loss and therefore, depending on the method of distribution, being potentially less likely than other class members to participate in any award of damages, can, if appropriate, be addressed in communications to class members. And there's then a discussion of how those communications could be formulated. We see at paragraph 64 what this is. It is an example of an application post-judgment of this case of Gutmann, one of the two cases that my learned friend Mr Harris referred to. And that's an illustration, really. It's obviously not binding on this court. It's an illustration in my submission of what happens at the end of the process. Nothing puts it back again, and there is no need necessarily for a finding at any stage under section 47 C2 on the individual loss suffered by any one class member in accordance with the statutory wording of the provision. And that's my short point on distribution.
I suppose it's right to say there's no requirement for individual loss. Section 47C confers a power.
Yes.
So could it be in an appropriate case that when it comes to distribution, the tribunal became of the view that there ought to be some individualised assessment, even if you'd used aggregation to that point? That would be open to them, I suppose.
Absolutely.
But it would just depend upon the facts.
Yes. I say, of course, that in a consumer type class action, it's hard to imagine how that's going to be appropriate.
Understood.
But
There are
of
sorts
course
of difficulties at the distribution stage that we're only just beginning to grapple with.
Yes. Well, we don't know yet. I mean, that's, in a sense, the next case.
Yep.
Now, that's all I wanted to say on that point, and that brings me to my third and final limb on point 1. My third and final limb is also relatively short, which is that I say I don't have to establish a rule that will govern every collective action in this appeal, in this case Gutmann. The regime is flexible. I think we all agree on this. Lord Briggs's words, the only requirement is that it should be just in the sense of being fair and reasonable. And yes, there may well be cases where individual assessments of loss will be possible and appropriate, will be fair and reasonable. In my respective submission, the judgment of the cat in this case is perfectly just, fair and reasonable in the circumstances of this case, where it's clear that there was a high percentage of overpayment. It is reasonable to assume no one would willingly overpay. There would always be some class members in a case of this kind that have suffered no loss. The presence of uninjured class members has no bearing on the calculation of damages against the defendants in this case. And the wording of section 47C, the statutory purpose, as discussed. I recall, of course, and there's no appeal against the opt-out nature of this, that without a CPO in this form, this case could never be brought. Nobody would bring a case of this nature for £55 or £33 on their own. And I come back to some of those aspects when I come to discuss the methodology. But in briefest summary on this point, it's a top-down damages assessment The alleged cases of no loss are at best a minority of cases, and the adjustment in the aggregate amount when I come to it, we say, is perfectly manageable. Now that would bring me to the question of the methodology, but for the US cases, which have also been briefly referred to. They're not relied on by the CAT, they're not even mentioned in the judgment of Lord Briggs. I will be, I suppose, to an extent guided by the court as to whether you want to hear from me on the US cases. There is certainly something to be said about them, and in particular Azakol, which has been relied on squarely by my learned friend, even though I'm going to say that I would ask the court really to treat the US cases in the way that the Supreme Court did, which is by simply not referring to them at all. I mean, there's a tradition in early English novels of a tale within a tale. It's a good example is the story of the Old Man of the Hill in Joseph Andrews by Henry Fielding. That the reader could skip the tale within the tale without losing anything of the main plot. It was an unconnected story told by one of the characters, usually quite rambling, with nothing to contribute to the narrative. And my submissions on UK cases are going to be like the story of the Old Man of the Hill.
US case.
What did I say?
UK.
Oh, I'm so sorry.
Those might be questions.
Yes,
Freudian slip.
of the US cases. Yeah, they really don't assist being too different.
The CAT's, on Azakol, the CAT just differentiated Rule 23B of the US federal rules from the domestic rules.
Yes.
And on Torres,
The problem is it's quite hard simply to dip into the US cases without at least a little bit of context. May I give it a try? I submit there is enough time.
have a go at Azakol.
Yes.
I'll have a go at Azakol. I should perhaps start, though, with where Azakol came from. Azakol is only to be understood, as my learned friend also explained, in relation to its predecessor case, which was Nexium. So Nexium is at Authorities tab 30. I think that's bundle.
I think the American authorities dealt with in your skeleton.
I believe they are. But only in paragraph 58, quite briefly, with a footnote. And it's really the footnote that, as the tribunal observed in 119, Azakol is controversial. It's contrary to the Ninth Circuit in Torres. It can't be squared with two US Supreme Court cases, Halliburton and Tyson Foods, both of which Azakol seeks unconvincingly to distinguish on the facts. And as we submitted to the tribunal, Azakol has been criticised by other courts, including within the same circuit, a lower court in re Lustrin. Very, very briefly, an explanation of this. If we look at Nexia, which is a
Nexus is a case in which Judge Kayata dissented.
yes,
By the time we get to Azakol, he was in charge of the courts. He was able to, as it were, impose his own will. I think we've all come across that sort of issue.
that's why Azakol is.
That's going to say Lord Denning.
That's why Azakol is known as Judge Kayata's Revenge.
I hear. And Torres takes a different approach, a different circuit, but takes a different approach.
Yes, I mean, if we just look briefly at Nexium, at tab 30, 1094, It starts at 1079. But if we look at 1094, there's a reference to essentially what the Supreme Court said in Halliburton. That's all I'm going to mention about the Supreme Court case of Halliburton. 1094.
We're at 1094.
Yes. Page 24 of the report, where the Nexium First Circuit Court says, thus the Halliburton Court contemplated that a class with uninjured members could be certified if the presence of a de minimis number of uninjured members did not overwhelm the common issues for the class. The law in this circuit is not to the contrary. And then, of course, we have the dissenting judgment of Judge Kenyatta in that case. Now, in Azakon, that's at tab 33. The plaintiffs there, they alleged a violation of consumer protection and antitrust laws by a drug manufacturer. I think my learned friend has explained the background. The drug was Azakon, and it was withdrawn from the market shortly before the patent expired, delay, that sort of case. They simultaneously introduced a similar but not identical substitute drug with much longer running patent. It was alleged this had the effect of causing the putative class to pay higher prices for the branded medicines. When absent the impugned conduct, a cheaper generic would have been available. The district judge had certified. The court presumed that approximately 10% of the class had not suffered any injury because they wouldn't have switched to a cheaper generic, but considered this was a de minimis number and the uninjured class members could be removed by a claims administrator. So far, one might say, in accordance with Halliburton and the Supreme Court. Now, the First Circuit reversed the district court. The question for the court to consider was at 1151. At second column, between the hole punches, last sentence, can a class be certified in this case, even though injury in fact would be an individual issue, the resolution of which will vary amongst class members? The plaintiffs, relying on Nexium, proposed using affidavits from class members, and the court held this wasn't permitted because the defendants said, well, we're going to challenge any affidavits. And at 53, that's 1153 of the bundle, the last paragraph, relatedly, this is not a case in which a very small absolute number of class members might be picked off in a manageable individualized process at or before trial. I pause there to say that at least if you translate that into the aggregate language, we say that's not our facts. Rather, this is a case in which any class member may be uninjured, and there are apparently thousands who in fact suffered no injury. The need to identify those individuals will predominate and render an adjudication unmanageable absent evidence, such as the unrebutted affidavits assumed in Nexium or some other mechanism that can manageably remove uninjured persons. Now, of course, this is all about the question of predominance, which matters in the US jurisprudence because that's the nature of the test. Our cases are not about predominance. We say that's a principal reason why the US system is not helpful to the UK system, very different. But then also at 55 is another reason. In the second column on page 55, that's 1155, the bundle, starting at the first hole punch, we are told that Article 3, and this is a reference to the US Constitution, nevertheless precludes per se the knowing use of a civil suit to make an award to an uninjured person, see Tyson Foods. There's an explanation. In many instances, the aggregate damage amount is the sum of damages suffered by a number of individuals. The nub of it is, a few lines down by the second hole punch, in such a case, the defendant must be offered the opportunity to challenge each class member's proof that the defendant is liable to that class member. So my learned friend says, well, this isn't some special American rule, it's just basic rights of the defence. In fact, it is the American Constitution, as explained in Tyson Foods, that judgment is also in the bundle if one wants to look at it, that prevented, in the view of Judge Kayata, the certification in this case, because he found the Constitution meant you had to offer the opportunity to challenge each class member's proof. Now, as I say, this is all terribly interesting, but a different system, and really we have little to learn from it, not least because we say it doesn't meet the statutory language of section 47C. But for what it's worth, that's the argument around Azakor. The court in Azakor recognised at 1156 that they left the system with a problem. So on page 56 of the judgment, 1156, the last paragraph, we recognise that there remains the problem of how to deal with conduct that inflicts small amounts of damage on large numbers of people. And there's a reference to the policy at the very core of the class action mechanism to overcome the problem that small recoveries do not provide the incentive for any individual to bring a solo action. And between the two hole punches in the second column of that page, in reaching our conclusion, we acknowledge the divergence evident in the manner in which our sister circuits have addressed the treatment of uninjured putative class members. There's a reference in the second column of the next page, 57, for instance, to Torres. But it's simply a reference to Torres. It's not somehow distinguished with reasons, as is suggested somewhere. Well, I think it's my learned friend skeleton argument. So, well, in Azakor, they took into account Torres. No, it's just dealt with by recital, and it's then weakly distinguished in the last paragraph of 57. No case cited above, nor in any case to which we've been directed, has a federal court affirmed the damages judgment in a class action against a defendant who was precluded from raising genuine challenges at trial, and so forth. So that's where one gets to with that, and we have the reference in our footnote also to what is said in Lustrin by a lower court in the same circuit. So this is the First Circuit, which, unlike, for instance, the Ninth Circuit in Torres, didn't certify in such situations. And in volume 7 of the authorities bundle, we have Judge Smith in Lustrin at tab 60, the very last authority in the bundles. That was a class action about an oral contraceptive called Lustrin 24 FE.
Yeah.
And Judge Smith found himself bound by the higher authority in his own circuit in Riasacol. This is where he says at 2351 of the bundle, having spent the whole judgment wondering whether there's a jurisdictional way of finding himself not bound and concluding there wasn't, he says in the second column of 2351, between the two hole punches, were the court writing on a clean pre-Asacol slate, it may very well adopt a presumption of injury. The court is troubled that over 90% of consumers in the proposed EPP class may have been injured by defendants' alleged unlawful conduct, but now have no practical recourse under antitrust law. Siri in Tuniv expressing similar concerns and noting that while Asacol eliminates the possibility that some consumers might obtain a recovery for damages they did not suffer, it also ensures that a much larger number of consumers will receive no remedy for harm actually suffered. Perhaps the Court of Appeals will have occasion in this case or another to reconsider this holding, or if not, perhaps Congress will take up the issue. But for now, the EPP's argument is not supported by the law of this circuit. So what we have in Azakol is we have a particular development in one circuit of the United States that is recognised even in that circuit as being problematic.
It's not a very promising start for what this court ought to do in circumstances where, on any view, the highest it can be put is it's of some, it's capable of being at least a persuasive analysis if that's the way that we regard it. If it's being criticised within its own circuit, it's not the law in other parts of the United States. It doesn't seem to be, at least, that it really assists this court very much at all.
And very hard to see how it could be squared with Halliburton and the other Supreme Court authority. And so that is what I urge upon this court. First of all, the systems are different. The predominance requirement, that's the requirement in Rule 23b of their law. Questions of law, fact common, must predominate over any questions affecting only individuals. That is a completely different question, a different statutory question. Forms no part of UK law. As all of the US cases are all to be approached with caution. And that point was accepted by the tribunal at paragraph 118. Furthermore, in the US there are constitutional principles in play, such as Article 3, which seems to be an important part of the ratio of Judge Kayata's findings. By contrast, we have the Supreme Court telling us that the compensatory principle is expressly and radically modified where aggregate damages are available by necessary implication. That means that it cannot be the same situation that any defendant can say, no, I require to challenge each individual case. And then to the extent it's relevant to consider it at all, as my Lord the Chancellor points out, it's a question that's controversial in the US, even in the same circuit. And it would be, in my respectful submission, a most unfortunate route to take at this stage of developing the UK system, to follow Judge Kayata down the dead end of not certifying such cases, where precisely the very thing will happen that Judge Smith says will happen. In our case, 90% of the travellers will not recover because potentially, say, up to 10% can't. So that's, again, a very long tail within a tail, only to say that I invite the court not to follow the US case law. Now, Lord, that was all I planned to say about Merrick's, about the Canadian case law, the US case law, and all of those points made by my learned friend Mr Harris. My learned friend Mr Harris then went on to make some points in advance of the more detailed points made by Mr Jowl about methodology. So that's where I would propose to go next. And in the time I have left available to me today, what I propose to do is to set out some of the more general points about the evidence and about the law, and then deal tomorrow with some of the more granular points that were raised this morning. As we see it, there are essentially 2 points made against us. One is whether the tribunal erred in law when it concluded that there was a realistic and plausible methodology, specifically in relation to the overlap and perhaps to a lesser extent, but also the removal of any point-to-point tickets. There is also, then, the question of the partly overlapping exceptions identified by both South West and South East as to whether exceptions can appropriately be dealt with on an aggregate level. I'd like to start, as I did in relation to the issues, I'd like to start just reminding ourselves as to the appropriate methodology which is set out or summarised in the judgment, core bundle, page 188 and following. Starting at paragraph 142. Where the CAT explains in outline the method which we propose to use. And there are of course the two reports, Hold 1 and Hold 2, in the supplementary bundle. Fundamental to Mr Holt's method is that it is based on the number of passenger journeys, not the number of passengers. So the size of the class is irrelevant to the means by which he seeks to estimate the aggregate loss suffered by the class as a whole. And the methodology itself is then explained over the following pages. To summarise, it consists of 4 steps. Step 1, number of in-scope journeys. That's estimating the total number of tickets sold by South West and South East during the claim period for journeys originating within a TfL travel zone and terminating beyond the zone's outer boundary. So simply speaking, journeys outbound from London. I submit relatively straightforward. 2, the savings from cheaper boundary fares. So step 2 seeks to estimate for each of the journeys that we've just identified in step 1, what the saving would have been if a boundary fare had been used. And in a sense, very basically, this involves comparing the price of a boundary fare, a full journey fare, for each origin-destination ticket pair, and in 27% of the cases for South West and 12% of the cases for South East, they don't exist at all. So that's an issue where Mr Holt has estimated the price of the missing boundary fares by using an average, and for the rest of the tickets, the majority of the tickets, there will be an actual boundary fares, an actual boundary fare. Again, not massively controversial. We've seen some of the figures. Step 3 is the overlap. So step 3 estimates how many of these journeys are made by travel card holders. Now, this data is not actually recorded, that's common ground. So that is why Mr Holt has had to estimate it. And what he's done, he's looked at the patterns of onward journeys made from the big London rail termini, so passengers arriving by train, travelling on to somewhere else, and specifically how many were made by tube and bus, and multiplied that with information about how many tube and bus journeys are made using travel cards to get a proxy for how many rail passengers likely have travel cards.
So for example, would you take journeys by tube using travel card from Liverpool Street Station?
Yes.
Even though you don't know what happened prior to then, you make an assumption that a proportion of those underground journeys were preceded by a train journey using a travel card. Is that?
Yes. That's how it works, and that's a not unusual method of using a proxy in a situation where no data exists. And it is as a refinement of that average that the issue of the survey comes in. Because at trial, Mr. Holt says he intends to refine his method by the survey, which he considers, and the tribunal agreed, would be apt to provide him with the information he needs.
And it's clear from 148 that this onward journey analysis is derived from TfL's own internal analysis of onward travel patterns.
Yes, it's the TfL Termini report, and that is where it is to be found, and it's also in table 623 of Hold 1. And then, of course, the defendants made a number of criticisms of the methodology, and Mr. Holt produced his second report, which did a number of things, including expanding on the potential use of the survey to refine his estimates as part of step 3. Now, before I come to that, just to complete the picture, step 4 is entirely straightforward. Step 4 subtracts the, we say, very small number of boundary fares that were actually sold from the estimated value of the claim. And thus you reach Mr. Holt's initial figure. Now, this point is set out, these 4 steps are set out in detail in section 6 of Mr. Holt's first report, and it's summarised in that part of the judgment. It's, since my learned friends went there, it is perhaps as well to set it out, to just show the court in supplementary bundle 2 at tab 12, Mr. Holt's first report, and the relevant section starts at page 404, the section 6 headed quantification of passenger harm. And this is the section from which my learned friend Mr. Jowl partly read this morning. And I'll come back to some of that tomorrow. But at 431, under the table to which I drew my Lord Justice Green's attention just after lunch, that's table 624 about in-scope journeys, which gets you to the 90 plus figure. There is the heading Further Refinements to Calculations on Travel Card Holding. And in 6273 on page 431, there are several potential future data sources that would enable me to refine my estimate of travel card holding. These include A, customer survey. This would involve asking TOC railfare purchasers whether they had an active travel card when they made their journey. Questions could also include journey details, e.g. OD to exclude journeys that are not relevant, and travel card details, daily, weekly, monthly, annual. However, I would need to treat the results carefully, as a survey today may understate the share of travel card holdings for prior years, given the increasing prevalence of contactless payments. Could be mitigated by asking a question over previous travel card holdings. And that is then expanded on in the second Holt report, which is at tab 13, and specifically at page 512 following, section 3.6, refinement to my estimate of travel card holding using a customer survey. Now, I will say, in defence of Mr. Holt, who obviously isn't here to defend himself, it is, I submit, extremely unfair to suggest that somehow not even the slightest outline of the survey has been suggested, or that Mr Holt has somehow just blurted out the word survey without any further particulars. And for instance, we have here section 3.6, where he explains that in First Holt he identified potential
We've got
sources.
6 pages of analysis of what the survey would look like from here on in.
Well, I thought, yes, exactly. So very, very far removed from a situation where, I mean, we don't have a transcript, but there were various ways in which this was put. Not a single question, just using the word survey. For instance, just glancing at 3.6.10, the questionnaire would need to capture the following data: where a passenger is travelling from and to, where the fare was purchased, date of travel, fare type, reason for journey, recurring journey, yes, what frequency, do you have a travel card, what type of travel card, etc., etc. And then interpreting the results and so on, including right down to re-weighting the survey responses at 517.
And the context in which he does all that is to answer the point at 3.6.4, the suggestion by the defendants that the survey was completely pointless, effectively.
My lord, yes,
Didn't
exactly.
give any real value. He
Yes.
says, whilst I haven't been asked to specify or carry out a full customer survey at this stage, I am below the high-level questions and how the results could be adjusted to meet the objective of informing us of travel card holding during the claim period. So if you were looking at it in terms of methodology, he's setting out here, at least in a skeletal form, a methodology that he's going to employ.
My lord, yes. That's exactly.
Indeed, the very next heading is survey methodology.
My lord, yes.
But the essential point for the purpose of this appeal is whether the tribunal was right in 155 to say that Mr Holt had put forward a detailed and sophisticated methodology for estimating aggregate damages and paid close attention to data and information that either is or may become available.
Yes.
Now, is the CAT entitled to say that? Is that within the scope of their discretion, their judgment? Or were they required to go on and actually require Mr Holt to produce the survey for the purpose of certification? Is that what it boils down to?
It does, my lord. At paragraph 3.6.1, he says, I identified potential sources of data, including a customer survey. Well, the CAT has accepted that, amongst the rest of it. As I've pointed out, the survey is actually just a part of the overall assessment. And I say that there is nothing close to the quality of a manifest error that would be required. And what is, I ask rhetorically, what is this court to do? To look at it de novo and say, well, I'm not sure about it. But that's precisely what, with respect, you're not allowed to do. Even if you, my lord, came to the view that if you had sat there in the CAT, you might have come to a different conclusion. That's not the function of this court. It has to be so manifestly erroneous as to amount to an error of law, and Edwards and bears no
Where is a
sense.
question of discretion or evaluative judgment by a specialist tribunal, which is what we're concerned with here. As I think we said very clearly in the Patteral,
Yes.
it has to, in effect, to be manifestly wrong before this court will interfere with it.
That's right. The fundamental issue is that in paragraph 56, I think your lordship is referring to in Le Patteral, where the court said, where the challenge is directed at a decision about facts prima facie, this will not be a matter falling within the jurisdiction of the Court of Appeal, because it will be the outcome of an exercise of judgment and not an error of law. Nonetheless, the exercise of judgment over facts can on occasion amount to an error of law, for example, where the decision in dispute is outside the generous bounds of that which the decision maker, here the CAT, could properly and reasonably make. That's in addition to the point around specialist tribunal.
And it's the point that's made, I can't remember who first made it, maybe Lord Justice Lewison, who certainly made it more than once, which is that one of the reasons why this court is so reluctant to interfere with these sorts of evaluative assessments is that the tribunal or the court below sees the whole picture, and all we ever see is a snapshot.
Well, indeed. And a perfect example, to some extent, of the snapshot is what we experienced this morning. I'll come back to that tomorrow. But what very often happens when one comes to this level is that a point that was perhaps a detail, or part of a detail of the judgment below, is suddenly magnified into the point of appeal. And you suddenly end up spending 1.5 hours on these so-called exceptional points.
Especially if it's done by a beguiling applicant.
Indeed, and beautifully done at that. But nonetheless, you're dealing with aspects that were merely a fraction of all the things that the multifactorial assessment which the tribunal engaged in below involved when viewed as a whole. And I haven't stood here and enumerated all the things that were said against me below that have not been appealed against. But that all falls to be weighed in the balance when it comes to the question of going outside the generous bounds of that which the decision maker could properly and reasonably decide. And we see, for instance, on that note, that the whole of Hold 2, we haven't dealt with most of the other points, but the whole of Hold 2 was a response to the points made by the other side in their evidence. If one looks at page 488, Mr. Holt explains the focus on the methodology and how he's read the relevant passages of Mr. Cameron and Mr. Joyce and Mr. Backwell and sought to address some of the main concerns, 113, not intended as a line-by-line rebuttal. So this is the answer to many points, not just this point. But it goes hand in hand with Microsoft and process. So when one looks at the legal principles that govern this, on the one hand, we have the Edwards and Bairstow type jurisdictional conduct, but then also we have the sort of test, or the precise test that we're dealing with here. So common ground, that is Microsoft paragraph 118, sufficiently credible or plausible to establish some basis in fact, with a realistic prospect of establishing loss on a class-wide basis, more than purely theoretically or hypothetically grounded in facts. That is already, with respect, a relatively low bar in my submission. So you have not only the manifest error problem with jurisdiction, a problem for my learned friends, you also have the fact that you are operating not within some of the statutory fields, perhaps at a full trial, but you're dealing with the certification stage and the relatively low bar of plausibility, some basis in fact that is required for the expert evidence at this stage. On no view can it be submitted, as my learned friend at least comes close to submitting, that we have to produce the entirety of our expert evidence at this stage, or that we have to produce, for instance, the detailed survey. My learned friend Mr. Giles says, well, what we should have produced is at the very least a statement from a survey expert about how he might have done the survey and what it would have cost. When one could do, that cannot be, so that cannot be read as a requirement sine qua non of the double situation of producing something credible or plausible with some basis in fact, and the cat being entitled properly and reasonably to come to the view that that is enough for it to exercise its relevant discretion. It comes nowhere near with respect what is required in this case. And of course, we also have not only Mr. Holt's written evidence, we also have Mr. Holt's oral evidence. The tribunal questioned Mr. Holt on day 3 of the CPO hearing, and the judgment at paragraphs 154 and 155 records the tribunal found his evidence and answers very helpful in understanding and assessing his methodology. And it should be apparent, even from the simplified description set out above, that's the summary of the tribunal, that Mr. Holt has put forward a detailed and sophisticated methodology for estimating aggregate damages and paid close attention to the data and information that are or may become available. And I respectfully submit one cannot fault that finding. My lords,
This was a sort of a hot tub, or maybe a lukewarm tub.
it was a hot tub, but with only Mr. Holt in it, because of course
No other expert.
the other side hasn't produced an expert yet.
But no cross-examination, only questions from the tribunal.
There was the opportunity for questions from anyone, but no cross-examination, no. And it's worth pointing that out, because quite unconsciously, of course, my learned friend Mr. Harris at one point said rhetorically yesterday, we asked the question so-and-so, answer came there none. And he obviously wasn't talking about cross-examination, but what one might have gained the impression from that somebody from the other side asked Mr. Holt a question. They did not. As I say, we say the survey was not only not one where there was no description whatsoever, but in fact very fully set out. And even if one were to go so far as to accept Mr. Jowell's point that we should have heard something more about someone with expertise. Well, Mr. Holt himself, of course, is perfectly used to using and evaluating surveys, and he has described in his report how he's going to do it. So to the extent that something might have been required, quod non, I say, it has been provided by Mr. Holt. And also, Mr. Harris's point that, well, we've provided a number of theoretical scenarios, and Mr. Holt hasn't come up with a detailed expert methodology in relation to each scenario at the certification stage. That again suffers from the same flaw. That is going far too far in relation to what is required at this stage. There is nothing wrong, my lords, with my lady, with refining the approach later. And I'm going to say 2 more things about that. The first is what is the approach that was taken by the CAT in a case called Qualcomm. And I'll show your lordships and my lady that in Authorities Bundle 7, tab 59. Tab 59. It's a judgment of Mrs. Justice Bacon, again Professor Mason and Mr. Turner QC sitting as the tribunal, and that's Mr. Justin Turner. It's an application by which for Collective Proceedings Order pursuant to 47B. It's a combination of standalone claims about Qualcomm abusing its dominant position in relation to royalties charged by them to smartphone manufacturers for the licensing of patents for chipsets. And the essence of the abuse is said to be that they leveraged a dominant position in the supply of chipsets into patents so as to charge inflated royalties for the use of those patents, which are then said to be passed on to the final consumers of smartphones. Proceedings proposed to be brought on behalf of all those consumers who have made UK purchases of LTE-enabled Apple and Samsung smartphones since 1st of October 2015, around 29 million. What is, I submit, interesting is to look at how the tribunal looked at the model that was put forward in that case. At page 2302 of the bundle, the question for the tribunal, 81, the question for the tribunal will ultimately be whether the expert, Mr Noble's, hedonic regression analysis sufficiently controls for all other relevant factors that causality can be inferred from whatever evidence of correlation between prices and variable costs the model produces. And then there's an explanation of the proposition. At 82, it is therefore possible that having assessed the robustness of the model, the tribunal might conclude that no inference of causality can be drawn from it without additional qualitative corroborating evidence from Apple, Samsung and others. But that will turn on the assessment of the results of the regression model and detailed consideration of its specification at trial. We certainly cannot conclude now that Witch's case will inevitably fail without the evidence referred to by Qualcomm. At 87, there is a discussion of what Mr Noble was doing. He emphasised he had not yet determined exactly how to specify his regression model, but one question to consider would be the extent to take account of any non-linearity in the cost-price relationship. And there we are. This is, in our view, paradigmatically an issue that will fall to be tested at trial. By reference to the data as to the extent of focal pricing, the decisions made by Mr Noble in due course as to the appropriate specification of his model, and so on. And over the page they say they can't say yet whether his approach will prove to be flawed or not. 91, that position is in our view entirely reasonable. The objection at this stage is premature. Insofar as there remains a dispute as to this aspect of the model specification, that will be a matter to address at trial. It does not prevent certification. And similar points are made at 93, at 96. Now, this was a more populated hot tub and a much more complicated issue with respect than in our case. But in each case, the tribunal finds at 99 and 100, we regard this matter for debate at trial. As was apparent from the debate by the second hole punch in the hot tub, these are matters that will fall to be considered in the detailed model specification that is eventually adopted by Mr Noble. He hasn't reached a concluded view on any of the issues raised by Dr Padilla at this preliminary stage. We would not expect him to have done so. And his model was there found to be sufficiently robust. Now that's obviously on the facts of that case.
And that's actually a case where Qualcomm called its own expert, and there was indeed a hot tub.
Yes, exactly.
Process.
Yes. That is, again, it's a case that's not binding on this court, but it is, in my respectful submission, a perfect illustration of how expert evidence in that case, contested expert evidence, is to be treated, and it illustrates the correct approach. And so we say there is nothing in the arguments made by both my learned friends that Mr Holt hasn't provided a version of the survey that he's intending to rely on. The tribunal explored these issues with Mr Holt, leading to the conclusion at paragraph 159 of the judgment, page 193 of the core bundle. We accordingly reject Mr Harris's submissions, and they were in essence the same arguments made before this court, that Mr Holt's step 3, and thus his methodology, should be dismissed as not properly grounded in the facts, as Mr Harris argued, not fit for purpose. As noted above, it is not appropriate to go further at this stage and determine the robustness of the method. And there's a further comment specific to survey design if we turn on to paragraph 162. And that comment is, it would be wholly disproportionate to expect a CPO applicant to engage survey consultants and produce their evidence at the certification stage, unquote. And we agree. So, my lords, that's all that I wanted to say about the survey. It may be, my lords, that this is a convenient moment to break. I know I haven't reached 4:30 yet, but I will now come on to the issues in relation to the scenarios.
Yes. Well, as we said yesterday, we're not tying anybody's hands, but we'd very much like to finish this these appeals by lunchtime tomorrow.
I believe I have until 12 tomorrow,
Right.
and I'm confident, Council's estimate, I'm confident that I will sit down at 12.
Good. Well, as long as you're confident of that, otherwise we might have to start slightly early tomorrow, but if you think not, then let's say 10:30 tomorrow morning.
My lord.
Brilliant.